friends, and welcome to another WSIB Truth Matters with Joe Machado. Today, I'm going to be doing the third video on the 5-part series. For those of you who've been following along, I appreciate you taking the time to watch my videos. And if you can share them to others who you think might benefit from this content, that would be great. So today, the third video, I'm going to be talking about the issue of future economic loss, retroactive benefits, and how they affect retirement income. So this does apply to claims under Bill 162 that came into effect January 1st, 1990, up until December 31st, 1997, at which time Bill 199 was, or Bill 99 was implemented. So it does apply to FEL benefits strictly, but there are other tribunal jurisprudence that can deal with issues pertaining to Bill 99 claims, if that's in fact the legislation covering your particular claim. So what does it really mean, future economic loss, retroactive benefits, and retirement benefits, and how does it sort of commingle? Well, under the law, if a person was found to be able to or eligible for a future economic loss award under Section 44 of the Workers' Compensation Act, and there's one of three time frames where the future economic loss, the first review or the determination would have been made. So the first one is if a person had an injury or contracted an occupational disease and had been in receipt of total temporary disability benefits for a period of consecutively for 12 months. Then the board would have been compelled under the law to make a future economic loss determination. The other criteria is if the person was found to have been left with a permanent impairment award, which would prompt a non-economic loss assessment, then that would have been the appropriate time to conduct that FEL review. And the third is if neither of those applied, so the person may have received 2 or 3 months of total temporary disability, then back to work, or within those 12 months, or a non-economic loss had not been determined yet within those 12 months, then the board could extend that time frame to 18 months after the injury. And the reason why this is so important is because it will have a significant impact on not only your future economic loss benefits, but also your pension. More specifically, the 10% that the WSIB is required to set aside for loss of retirement income. And so in this case, it was very important to get that decision retroactive to the earliest point that a review would have taken place. So now I'm going to talk to you specifically about a tribunal decision. This one here is decision number 11110/19. I am going to put it up on the screen so you can follow along. I'm going to refer to certain aspects of the decision. But yes, this person had to go all the way to the tribunal to get that date of his determination changed, and it was made on July 23rd, 2019. So some of the background of this claim: the person had a left ankle injury in August of 1997. In 2004, it's quite a while later, there was appeals involved. But in 2004, the appeals resolution officer in the appeals branch found that the worker was entitled to further benefits You'll be able to read in the decision, if you download the decision, all that was involved with the appeals branch granting further benefits. But here's the crux of the matter. To go back and pay those retroactive benefits, the claims adjudicator paid them as a total temporary disability. And so he did receive quite a significant amount of money, but he wasn't able to receive the 10% loss of retirement income pension that if the FEL award had been granted earlier from the time that he was fully disabled, and that amounted to quite a bit of money. So he appealed that decision. He received the total temporary disability benefits, but he appealed the decision to get the date where the total temporary disability was paid from, to get that date as the date upon which the future economic loss determination was made, so that all of those arrears benefits for those years would have prompted or compelled the board to pay the 10% loss of retirement income that the law provided for under Bill 162. So I'm going to put it up on the screen here and show you how the appeals resolution officer justified sticking with what the claims adjudicator had decided in terms of paying that period of benefits as total temporary as opposed to FEL. So here it goes. So the ARO in the decision dated May 10, 2018 stated, the FEL award is a prospective benefit based on what a worker is considered to be able to earn going forward, given the worker's impairment and transferable skills. It was not until August and September of 2004 that the claims adjudicator determined that the worker was competitively unemployable. Thus, the FEL award was determined and granted at that time, which is hogwash, really. It's a cop-out, it's bullshit, and quite frankly, it's inexperience, really. Because as you're going to see from the tribunal jurisprudence, the appeals resolution officer had the latitude within subsection 12 of section 44 to actually go back and pay those benefits or order those benefits to be paid as a FEL award. So I'm going to go back on the screen here and I'm going to show you what the panel looked at and how they rendered their decision in favor of the claimant. So the panel notes that under subsection 12, the board is allowed to extend the time limit set out in subsection 10 in cases where a worker is not receiving compensation under the Act and whose entitlement to compensation is in dispute, which was the case here. Section 44 of the pre-1997 Act makes provisions for payment of benefits for loss of retirement income equal to 10% over workers' FEL benefit. 44 subsection 1, for the purpose of providing a worker with who is receiving compensation under section 43 with a retirement pension, the board shall set aside for the worker additional funds equal to 10% of every payment made to the worker under section 43. So the total temporary disability benefits were paid under section 43. Subsection 10 states the three timelines upon which the FEL can be determined. And subsection 12 basically indicates that the board has the authority to extend those timelines, which if not the claims adjudicator, the appeals resolution officer ought to have known that. So then in decision, they go on to reference other tribunal decisions. In decision number 1553/04, The panel found the tribunal jurisprudence indicates that where there is a clear entitlement to wage loss benefits on a retroactive basis following the resolution of a dispute, which has prevented a FEL determination, the circumstances of the individual case must be considered in determining whether to award temporary benefits or a retroactive FEL award. There is no barrier either in the statute or board policy to a retroactive FEL determination. See also decision numbers 2309, 05 and 258710. So as you can see, the appeals resolution officer should have known better, that there was the authority within the act to extend that review period, but for whatever reason chose not to. And that's very unfortunate because if you can see, this decision was made in 2018 and the previous decision to allow retroactive benefits was made in 2004. That's quite a number of years to get justice. If only these people were experienced enough or knowledgeable enough or just took the time to understand the law. Or you know what? Go on the tribunal website and look for jurisprudence on issues that you're dealing with as a claims adjudicator or as an appeals resolution officer. Check out the tribunal website. That is a resource that you can rely on. Vice-chairs, they do that. They look at tribunal jurisprudence, decisions that were made from other panels. There's no egos here. At least there shouldn't be. But yeah, do your due diligence. Do your homework. Like, what the fuck? Making decisions like this that are just totally ridiculous and out of touch with reality and just exemplifies just how inept board people are at making fair and just decisions based on the law. It's pathetic. I apologize for my term there, but you know, I've said this before on my channel. Sometimes there's no other term that really expresses my total disdain for these people. It's awful, awful. Anyway, so I'm going to put up on the screen here another one from that decision where the vice chair made it clear what should be considered, what factors should be considered when doing that retroactive review to determine whether it's total temporary disability or a FEL determination that should be made. So here we go. So in assessing whether a D1 FEL date can be set retroactively, the principal issue that tribunal decisions looked at, and this is tribunal jurisprudence, was whether there was sufficient evidence regarding the worker's rehabilitative potential at the retroactive date. In this case, there was extensive medical evidence that the worker was competitively unemployable since the accident. And it's that evidence that the appeals resolution officer used to grant retroactive benefits in 2004. Go figure. Oh my goodness. This level of the ridiculousness, I think that's a word, is just pathetic. Some of you who may find yourselves in this situation after viewing this video, here's your roadmap. If you're dealing with an appeal, whether it's at the WSIB or the tribunal, or where they've made a previous decision where they paid retroactive total temporary disability rather than a full FEL at the D1 determination, so that first determination. This should help. As you know, my friends, my company, WSIBsettlements.com, we have all of the tools necessary and the docs, our settlement docs that I personally developed to argue all of these issues. And so if you become a member of WSIBsettlements.com, you're going to have access to a ton of resources and support to help you succeed in your WSIB claim. I took over 30 years of experience in dealing with the WSIB, at both the adjudication level, the appeals branch, and of course the Workplace Safety and Insurance Appeals Tribunal, and my firm of well over 10,000 clients and other paralegals in my firm. We've handled tons of this stuff. So I took all of that experience, what worked, and I put it into these tools to help you, regardless of your age, experience, academic background, language. My system that I put together, which is you can access all those benefits through our app. It's the only one of its kind. You'll be able to enjoy a lot of the benefits many of our members are enjoying, and it is at a very affordable price. So yeah, go on the WSIBsettlements.com and have a look at what we have there and decide whether or not you would benefit from our services. But regardless of whether you do that or not, this gives you a bit of a roadmap as to how to address this issue if you're confronted with this particular scenario. So coming up tomorrow, the third video of, actually it's the fourth video that's coming up tomorrow, and it's secondary entitlement, tribunal jurisdiction on sequential issues. Okay, it's very, very complex, a mouthful of a title, so I'll break it down. So basically, if you have a case that goes to the tribunal, and the tribunal is authorized or has the jurisdiction to rule on entitlement to, for example, a secondary condition that hasn't been addressed by the WSIB, and whatever benefits would flow from that entitlement, the tribunal would have the jurisdiction. That's called sequential issues. So I'm going to talk about that tomorrow, and I'm going to reference another tribunal decision for you to see basically how the tribunal addresses those types of issues. So friends, if you're not already subscribed to my channel, I invite you to become a subscriber. It costs you nothing. Nobody's going to be looking for money. All you need to do is click the subscribe button, and you're notified every time I come out with a new video, and you're supporting me in growing this channel. My goal is to touch every single injured worker in this province, past, present, or future, to let them know that we have resources to help manage their claims. I've got 30 years of experience and videos or material that I'm going to continue to talk about to help fellow injured workers and ill workers succeed in their claims with the WSIB. So yes, it helps me a lot if you're a subscriber. And please share my videos with others. I know there's thousands of injured workers out there who have either been misled or don't know where to go get help, or need help but they can't afford it, or there's all kinds of different scenarios. By all means, share my videos. You might be sending somebody a lifeline. And give me a thumbs up if you like my content. If there's something in particular that you would like me to talk about in one of my videos, send me an email at joemachado@WSIBsettlements.com and let me know what you would like me to discuss. I talk about everything from pre-1990 claims to Bill 162 and Bill 99 claims on a variety and a wide range of subjects. And if you have any questions about this particular issue, send me an email and let me know what it is, and I'll be more than happy to respond. All right, friends, and thanks a lot for taking the time to watch this video. And as always, take care now.